Hello Year 12s and welcome to this video on the relationship between courts and Parliament in lawmaking. There are 4 things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you want to go over any information contained in this video. The third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should write in your summary books. And the fourth thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you may be unfamiliar with. Once you've finished watching and taking notes on this video, please make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out the learning intention for this video. Please write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to analyse the features of the relationship between courts and Parliament in lawmaking. For these purposes, there are 5 features of the relationship between courts and Parliament in lawmaking. These are, first, the supremacy of Parliament. Second, the abrogation of common law. Third, the interpretation of statutes by courts. Fourth, the codification of common law. And fifth, the ability of courts to influence Parliament. You will note that in our learning intention, the task word that is used is analyse. Analyse means identify and closely examine the features of the relationship between courts and Parliament in lawmaking and show how these features are related. The information contained in this video will assist you to analyse the relationship between courts and Parliament in lawmaking. On this slide, I've set out a table that you should include in your summary books. The purpose of this table is to summarise the features of the relationship between Parliament and the courts in lawmaking. I've listed these features in the first column. You'll see that I've combined the first 2 features, that is, the supremacy of Parliament and the abrogation of common law, into one feature, that is, Parliament is supreme and can abrogate court-made law. This is because the ability of Parliament to abrogate the common law directly results from the fact that Parliament is supreme, that is, that Parliament is the ultimate lawmaker. As we go through this video, please fill out the remaining 2 columns in this table by describing each feature of the relationship between Parliament and the courts in lawmaking, and by giving at least one example of that feature that you can use in a SAC or exam question for the purposes of illustrating that feature. The key point that you should take away from this video is that Parliament and the courts have a complementary relationship in lawmaking. That's complementary. This means that both Parliament and the courts contribute to lawmaking in different ways, and that lawmaking by both Parliament and the courts is more effective than if only Parliament could make law, or if only the courts could make law. As far as Parliament is concerned, the primary role of Parliament is to make laws. Because Parliament represents the people, it is entirely appropriate that Parliament should be able to make laws for the people. Parliament makes laws in the form of statutes, also called Acts of Parliament or legislation. As far as the courts are concerned, the primary role of the courts is to decide cases that are brought before them. That is, to resolve disputes by applying existing laws to the facts of the case that they are hearing. Their primary role is not to make law. However, in order to resolve a dispute, a court may need to make law. For example, if the case that the court is hearing is not covered by an existing precedent, then the court may need to create or modify a precedent that it can apply to resolve that case. In creating or modifying a precedent, the court is creating a new rule or principle of law, which becomes part of the common law, that is, court-made law. In such a case, the court is making law. Similarly, in order to decide a case that the court is hearing, it may be necessary for the court to apply a statute made by Parliament. Perhaps one party has been charged with breaching the statute in a criminal case, or perhaps one party is claiming that the statute gives that party a particular right in a civil case. However, it may be that the words in the statute are ambiguous, or that it's unclear whether the statute was intended to apply to such a case. In that case, the court will need to interpret the statute to give meaning to words in that statute. In deciding what the words in a statute mean, the court is also making law, that is, law about what the statute means. So, the courts make law, but only as part of their primary role in resolving disputes. Unlike Parliament, a judge can't simply get out of bed one morning and decide to make law. Instead, before a judge, that is, a court, can make law, a case must first be brought before the court, which raises an issue that the judge has to decide. As you know, a case can only be brought before a court by a person that has standing, that is, by a person who is directly affected by the issue raised by the case. In addition to having standing, the party bringing the case will also need to have the time and money to bring the case. If there's no party with the standing, time and money to bring a case before the court, then the court can't make law. As I've said, courts only make law as part of their primary role in resolving disputes. That's why we say that the secondary role of the courts is to make law. Now, this isn't meant to suggest that the courts don't have an important role to play in making law. They do. It just means that courts only make law when this is necessary in order to resolve a dispute, that is, to decide a case. In the remaining slides, we're going to examine 5 features of the relationship between Parliament and the courts in lawmaking. These are the 5 features set out in the learning intention. That is, the supremacy of Parliament, the abrogation of common law, the interpretation of statutes by courts, the codification of common law, and the ability of courts to influence Parliament. Let's start off with the first 2 features, that is, the supremacy of Parliament and the abrogation of common law. As I've explained, I'm going to combine these first 2 features into one feature. This is because the ability of Parliament to abrogate the common law directly results from or flows from the fact that Parliament is supreme, that is, that Parliament is the ultimate lawmaker. When we describe Parliament as being supreme, we are referring to the doctrine or principle of the supremacy of Parliament, sometimes called the doctrine or principle of the sovereignty of Parliament. Parliamentary supremacy, or parliamentary sovereignty, means that Parliament is the ultimate lawmaker, and so it can make and change any laws within its jurisdiction and can abrogate, that is, override, law made by the courts. Look down the left-hand side of your vocabulary sheets, find the term parliamentary supremacy and write this definition in there. Note, however, that while Parliament can abrogate or override most law made by the courts, the one thing that Parliament cannot do is override the High Court's interpretation of the Constitution. It's because Parliament is supreme, that is, it's because Parliament is the ultimate lawmaker, that Parliament can abrogate law made by the courts. On this slide, I've set out a definition of the term abrogate. Parliament abrogates court-made law where it passes a statute that overrides court-made law. Look down the left-hand side of your vocabulary sheets, find the term abrogate and write this definition in there. As I've said though, while Parliament can abrogate most court-made law, the one thing that Parliament cannot abrogate is the High Court's interpretation of the Constitution. An example of Parliament abrogating a court-made law is when the Victorian Parliament passed legislation to override a long-standing principle of common law that a farmer is not liable in negligence where the farmer's stock, that is, the farmer's cattle or sheep, stray onto the public highway and cause an accident. You'll recall that Trigwell's case was the case of a couple, the Trigwells, who were driving along a road when some sheep strayed onto the road, causing a car coming in the opposite direction to swerve and hit the Trigwells' car, severely injuring the Trigwells. This case went all the way to the High Court, where the High Court refused to overrule the common law rule, which, as I've said, was that a farmer is not liable in negligence where the farmer's stock stray onto the public highway and cause an accident. Now, this common law rule was made well over 100 years ago when many people in England were farmers and there were no cars. Even the High Court agreed that this common law rule was outdated in a time such as now, where we have fewer farmers, fenced paddocks, and people driving their cars at high speeds along country roads. However, the High Court refused to overrule this common law rule because the common law rule had been in place for a very long time, and the High Court was concerned that it would be unfair to overturn this rule now.
This was because farmers were running their farms on the basis that they were not liable for road accidents caused by their stock, and so, for example, didn't take out insurance to protect them against this liability.
Well, after the Trigwell case was decided, the Victorian Parliament abrogated this common law rule by passing a statute that amended the Victorian Wrongs Act to state that this common law rule no longer applied in Victoria. That is, to provide that farmers could be liable in negligence for damage caused by their stock straying onto the public highway. You're now in a position to include in the table in your summary book a description and example of the first feature of the relationship between Parliament and the courts, that is, that Parliament is supreme and can abrogate court-made law. We now come to the second feature of the relationship between Parliament and the courts in lawmaking. This is that the courts apply and interpret the law made by Parliament. That is, the courts interpret and apply statutes. As you should know, there are two reasons the courts need to interpret statutes made by Parliament when they're deciding a case. The first reason is that the words in the statute might be ambiguous. That is, they might have more than one possible meaning. This was the situation in Degentrola, the studded belt case, where the court had to decide whether the word weapon in a Victorian Act meant something the primary purpose of which was to injure another person, or instead something that could be used to injure another person.
The second reason the courts need to interpret statutes made by Parliament when they're deciding a case is if the application of the statute is unclear.
That is, if it's not clear whether the statute was meant to apply to a case such as the case that the court is hearing. This was the situation in the Kevin and Jennifer case, where the court had to decide whether the word man in the Commonwealth Marriage Act included a person who was born female but subsequently had a gender reassignment operation to become a male. When the Marriage Act was passed by the Commonwealth Parliament in 1961, there was no such thing as gender reassignment or sex change operations, and so it was unclear whether the word man should only apply to a person who was born male or should now include a person who was born female but changed their gender to become male. You should also remember that one of the effects or consequences of statutory interpretation is that a court's decision about the meaning of a word in a statute can create a precedent about the meaning of that word in that statute. This precedent will be binding on lower courts in the same court hierarchy when they're interpreting that word in that statute. Alternatively, this precedent will be persuasive for higher courts in the same court hierarchy, or for courts in a different court hierarchy when they are interpreting that word. Another effect or consequence of statutory interpretation is that the court gives meaning to the word or words that it's interpreting. If the court gives a narrow interpretation to the word or words that it's interpreting, then this will narrow the scope or operation of the statute. Think back to the studded belt case. In that case, the court interpreted the word weapon narrowly to mean something the primary purpose of which was to injure another person. This narrowed the scope of the statute because it meant that fewer people would be guilty under the statute of carrying a weapon in public. Because a studded belt was not considered to be a weapon, people who wore a studded belt in public would not be guilty under the statute of carrying a weapon in public. Conversely, if the court gives a broad interpretation to the word or words in a statute that it's interpreting, then this will broaden the scope or operation of the statute. A good example of this is the Tasmanian Dam case. In that case, the High Court gave a very broad interpretation to the phrase external affairs in the Constitution by interpreting that phrase to mean any matter covered by an international treaty that has been signed by the Commonwealth Government. This significantly broadened the scope of the Commonwealth Parliament's lawmaking powers because it meant that the Commonwealth Parliament could now make a law about any matter covered by an international treaty signed by the Commonwealth Government, even though that matter would ordinarily have been within the state parliament's residual lawmaking powers. That is, even though in the absence of the international treaty, the Commonwealth Parliament would not have been able to make a law about that matter. You're now in a position to include in the table in your summary books a description and example of the second feature of the relationship between Parliament and the courts in lawmaking. That is, that the courts apply and interpret the law made by Parliament. We now come to the third feature of the relationship between Parliament and the courts in lawmaking. This is that Parliament can codify law made by the courts. Parliament codifies law made by the courts, that is court-made law, when Parliament enshrines or includes that court-made law in a statute so that the court-made law becomes part of the statute. Look down the left-hand side of your vocabulary sheets, find the term codify and write this definition in there. An example of where Parliament has codified court-made law is when the Commonwealth Parliament passed the Commonwealth Native Title Act of 1993, which enshrined law made by the High Court in the Mabo case. As you'll recall, in the Mabo case, the High Court overturned the common law rule that Australia was presumed to be uninhabited, that is, terra nullius, when Australia was settled by the British. The effect of this common law rule, which had been in existence for over 200 years, was that Australia's Indigenous people did not have any rights to land in Australia when Australia was settled by the British. However, in the Mabo case, the High Court overturned this common law rule and instead decided that Australia's Indigenous people did in fact have rights to land in Australia when Australia was settled by the British. These rights were called native title and gave Australia's Indigenous people the right to use the land for their traditional purposes, such as hunting, gathering food, and holding cultural and religious ceremonies like robberies. After the High Court had decided the Mabo case, the Commonwealth Parliament then passed the Native Title Act to codify or enshrine in that Act the concept of native title as defined by the High Court in the Mabo case and to regulate the treatment of native title in Australia. This Act defined native title, set out the procedure that needed to be followed to determine whether native title existed over particular land, set out the circumstances in which native title could be extinguished, and set out the process for calculating the amount of compensation payable to Indigenous people where their native title was extinguished. You're now in a position to include in the table in your summary books a description and example of the third feature of the relationship between Parliament and the courts in lawmaking. That is, that Parliament can codify law made by the courts. We now come to the fourth and final feature of the relationship between Parliament and the courts in lawmaking. This is that decisions of the courts can influence Parliament to change the law. One example of where decisions of the courts can influence Parliament to change the law is where a court makes comments about a law when it's deciding a case. These comments express the court's opinion about the law and are therefore obiter dicta. If Parliament agrees with the court's comments about the law, then Parliament might then change the law by passing legislation. An example of this is Trigwell's case. As we've seen, in Trigwell's case, the High Court refused to overturn the long-standing common law rule that a farmer is not liable in negligence where the farmer's stock stray onto the public highway and cause an accident. However, in that case, although the High Court refused to overturn this common law rule, it did recognise that this common law rule was outdated. While this common law rule was appropriate over 100 years ago when many people were farmers and cars didn't exist, it was not appropriate for the world we live in today, where there are fewer farmers, where paddocks are fenced, and where people drive their cars at high speeds along country roads. In short, while the High Court refused to change the law because it didn't think it should change such a long-standing common law rule, the High Court did suggest that Parliament should consider changing the law. And that is exactly what the Victorian Parliament did when it passed legislation to amend the Victorian Wrongs Act to overturn this common law rule. This is an example of where a court decision influenced Parliament to change the law. The High Court said that the law was inappropriate, and the Victorian Parliament responded by changing the law. Another example of where decisions of the courts can influence Parliament to change the law is where a court decision or the application of a statute or precedent by a court is considered to cause some kind of injustice. In such a case, Parliament can respond to this injustice by changing the law to prevent the law operating unjustly. This might mean that Parliament abrogates the law made by the court, or that Parliament passes legislation to change the statute. An example of this is when the Victorian Parliament passed the Sentencing Amendment, Cowards Punch Manslaughter and Other Matters Act of 2014. This act was passed because the Victorian Parliament felt that the courts were not giving sufficiently long jail sentences to offenders who killed another person when they attacked the person from behind without warning and punched them in the head or neck, with the result that the victim died either from the punch or as a result of their head hitting the ground. This is known as one-punch manslaughter. There'd been a number of cases of one-punch manslaughter, and the Victorian Parliament didn't think that the courts were punishing offenders as severely as they deserved to be punished. Accordingly, the Victorian Parliament passed the Sentencing Amendment, Cowards One-Punch Manslaughter and Other Matters Act of 2014, which requires the courts to give a minimum 10-year sentence of imprisonment to offenders who commit one-punch manslaughter. So, this is an example of where court decisions have influenced Parliament to change the law because Parliament doesn't agree with those court decisions. You're now in a position to include in the table in your summary books a description and example of the fourth relationship between Parliament and the courts in lawmaking. That is, that court decisions can influence Parliament to change the law. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to analyse the 5 features of the relationship between courts and Parliament in lawmaking. These 5 features are: first, the supremacy of Parliament; second, the abrogation of common law; Third, the interpretation of statutes by courts. Fourth, the codification of common law. And fifth, the ability of courts to influence Parliament. Don't forget to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.